I'd like to acknowledge the owners of the land, also the Gadigal people of the Eora Nation, whose land was never ceded. So as Peter said, AFTINET is a network of about 60 organisations. It's quite broad. It includes public health, church groups, unions, environment groups, women's groups, aid and development organisations. And we basically advocate for a more just trade system based on human rights, labour rights and environmental sustainability. And we focus on the social impacts of trade agreements, in other words, how they affect people's lives. And tonight I'm going to talk about the latest version of the Trans-Pacific Partnership, now known as the TPP-11. But I want to begin by putting it in the broader context of the debate about trade policy, because we're reading in the paper every day about Donald Trump's America First policy and the trade wars that really are underway now. So our struggle for a more just trading system is part of the wider debate about the failure of neoliberal or trickle-down economics to deliver the prosperity that it promised, about how instead it has increased inequality and why there is a need to develop alternative, progressive trade and economic policies which actually improve people's lives. We are fundamentally critical of neoliberal trade policies, which are the ones we have at the moment, but we also reject Trump and Hanson's simplistic nationalist policies of a return to high tariffs, building walls and discriminatory migration policy based on fear. And this will lead to trade wars which could have disastrous consequences for the global economy. So I'm happy to answer questions later about those broader issues, but I will actually get onto the TPP in a moment. But just to say that we do need, this is part of the struggle about needing to rethink trade policy and come up with progressive and inclusive policies which actually serve people's needs rather than just the 1%. So in talking about the TPP-11, I think we just need a bit of background first to establish that we all know that trade agreements are legally binding agreements between governments, and they're trying to remove tariffs or taxes on imports, but increasingly they're more about removing what they call other trade barriers to both trade and investment. And the theory is that this greater global competition leads to greater efficiency and lower prices for consumers. And it is true that there can be some benefits from expanded trade, but in the current context, we know from experiences like, say, the clothing industry, that increased competition can simply mean a global race to the bottom on workers' rights, trade and the environment. So we have that terrible memory of the Bangladesh disaster where workers with no rights were ordered back into a dangerous building in 2013, and the building collapsed and killed over 1,200 people, mainly women and children. That's the end result of neoliberal trade policies. And of course major Australian stores were actually being supplied by those companies in that building. So neoliberal trade policy often develops benefits for global corporations but increases global inequality. In theory, each country has to specialise in its own most narrowly defined competitive products, import everything else at the lowest possible prices, have no active industry policies and no government or minimal government regulation. So trade agreements are increasingly not just about reducing tariffs, because in Australia our tariffs are already very low, but they are about preventing governments from regulating corporations. But we do know from the global financial crisis, for one example, that unregulated financial markets fail and that governments must intervene to ensure responsible government and protect consumers. So the same with climate change. Governments have to respond, to intervene, to act, to encourage investment in low carbon industries and renewable energy. The same with global tax evasion. We have more and more stories about the need for government intervention to ensure that there is enough revenue to fund the services we need. So global corporations must be regulated at both national and global levels, but neoliberal trade policy doesn't recognise these lessons, and instead agreements like the TPP-11 seek to actively prevent governments from regulating in the public interest in areas ranging from medicine prices to food regulation to telecommunications, financial services, government procurement and many other areas. And it is global corporations that influence trade deals, and they want rules that suit their needs, but they don't suit our needs. I just mentioned something about the process for trade agreements as well, because this is very relevant to where the TPP-11 is going at the moment. As we know, they're negotiated in secret, and we don't see the text until after it's signed, after governments have agreed on the text and signed the deal. And this decision in Australia is a cabinet process. Parliament can't change the text, and it doesn't even get to vote on the whole text of agreements, just on the implementing legislation. And this often involves things like tariff changes or things that need to be changed immediately, but not a lot of the other nasty things that are actually in the text of the agreements. So they're actually designed to lock in future governments to stop them from regulating in future, and this obviously undermines the whole democratic process. Now, in terms of enforcement, they used to be enforced mainly through government-to-government dispute processes, but increasingly they also include what are called investor-state dispute processes, or ISDS. And this extra process enables a single foreign corporation to bypass national courts and sue governments for millions of dollars in unfair international tribunals if they can claim that a change in law or policy will harm their investment. So this is an additional threat to democratic accountability. And of course, part of our struggle is to get a more open and democratic trade process than the current one, and I'll come back to that later. So if we finally get down to the tin tacks of where the TPP-11 is up to, as we know, it originally involved Australia, the US and 10 other Pacific Rim countries, which is now being called the TPP-12. The countries involved span the Pacific Rim, so we've got US, Canada, Mexico, Chile and Peru in the Americas, and Japan, Singapore, Malaysia, Brunei, Vietnam, Australia and New Zealand in our region. And Donald Trump withdrew the US in 2017. But it's worth remembering that the push against the TPP in the US didn't come mainly from the right wing of politics. The main movement against the TPP in the US was led by progressive unions and community organisations that convinced Bernie Sanders to oppose it, and this then influenced Hillary Clinton to do so. So there was bipartisan opposition. Both Democrats and Republicans opposed the TPP in the US, and the US Congress did not endorse it. So when Trump came in with a policy that opposed the TPP, it was easy for him to withdraw from it. If we go back to that TPP-12, as President Obama said about it, it was about the US writing the rules for trade in the Asia-Pacific region. The movement in the US against it was because progressives in the US knew that it was basically giving more power to corporations and would stop even the US government from regulating in progressive ways on medicine prices, for example. And the US economy was larger than all the other economies combined in the TPP. So the US corporations lobbied successfully to include rules which suited them. So when the US withdrew, the other governments were faced with rules which they didn't really like, but they were agreed to them because they wanted to get access to the US market. So they solved this problem and kept the TPP-11 alive by only suspending some of the worst US initiated clauses, like longer monopolies on medicines. But they haven't been deleted from the agreement. They're still there, and it's been explicitly said that the intention is to reactivate them if the US rejoins the agreement in future. So the remaining 11 countries, led by Japan and Australia, took over a year to agree to a deal which was still mostly identical to the original TPP-12, except for the suspended clauses. They did add a non-binding preamble which mentions human rights but has no legal effect on the rest of the agreement, and they gave it a new name, which is the Comprehensive Progressive TPP, but nobody's using that name. They're now all calling it the TPP-11. So you can see that there was a bit of window dressing to attempt to make it look like a more friendly agreement. But essentially, the 6,000 pages of text are mostly the same. And we only saw the full text of the amended deal tabled in Parliament this year, and it's now being examined, it has been examined by a government-dominated joint parliamentary committee, which actually reported fairly predictably on August 22nd in favour of the implementing legislation. So we've already had the government-dominated committee saying the implementing legislation should be passed. Now, as I said, Cabinet made the decision to sign the agreement, and Parliament can't change it and can only vote in the implementing legislation. So that means the only way we can stop it is to get the majority in the Senate to block it. And that's what we're campaigning for. So why is it still so bad? Well, it has 30 chapters, but only 3 of them deal with tariffs or taxes on imports. The rest are about restricting the ways in which future governments can regulate investment and all kinds of other policies in various areas. And I just want to focus on 4 examples. And the first one is this investor-state disputes, or ISDS. Now, this gives foreign investors special additional rights to bypass national courts and sue governments for millions of dollars over health, environment, industrial and other public interest legislation, if they can argue that such legislation or policy harms their investment. Now, many legal experts, including the former Australian Chief Justice French, have said that these international tribunals don't meet the standards of proper national court system. There's no independent judiciary, for example. The tribunal members can remain practising advocates, so one month they can be representing a global corporation suing government, the next month they're sitting on a tribunal. There are no precedents and no appeals to ensure consistency of decisions. Now, in national court systems, once you're a judge, you can't continue to practice as an advocate. So you can see that it just doesn't fit any of the rules. And of course, global tobacco companies and global mining corporations have used this mechanism and said so publicly to systematically undermine health and environmental legislation. They see this as a way of preventing governments from regulating. And we all know that the Philip Morris Tobacco Company tried to claim billions of dollars in compensation for Australia's plain packaging law. Because of this case, which was so notorious, the TPP does clearly exclude tobacco regulation from ISDS, but that is the only clear exclusion. Other public interest laws are not excluded, even though the government claims that there are safeguards, but they all have loopholes, like saying except in rare circumstances, or provided that the regulation is consistent with the rest of the agreement, which means consistent with the rights of corporations. So the Howard Conservative Coalition government didn't agree to ISDS in the US-Australia Free Trade Agreement in 2004, but of course the current coalition government is promoting it. And also the previous ALP government had a policy against ISDS. and still opposes ISDS in its policy. There are now over 850 known ISDS cases, and many of them are against public interest laws. And just to mention some examples, a more recent public health one was the Swiss pharmaceutical company Novartis threatened an ISDS case against the Colombian government because it planned to reduce the price of a patented medicine to treat leukemia. Colombia is a very poor country, as you know. On the environment, the US Vilcon company won millions of dollars of compensation from Canada because its application for a quarry in an environmentally sensitive area was refused on environmental grounds. If we look at workers' wages, the French Veolia company is suing the Egyptian government over a contract dispute in which they're claiming compensation for a rise in the minimum wage. And one of the most disturbing recent cases concerns Indigenous land rights in Peru, where an ISDS tribunal ordered the Peruvian government to pay a total of $36 million to a Canadian mining company because it cancelled a mining licence after the company failed to obtain informed consent from Indigenous people, leading to mass protests. But the ISDS tribunal found that the company deserved compensation for ignoring what was both national and international law on land rights. There's an example of privatisation from Mexico where from Portugal, where a Mexican company threatened Portugal with an ISDS case for millions of euros after Portugal cancelled plans to privatise part of Lisbon's public transport network. So privatisation is often a feature of these cases. So these examples show that ISDS can be used against government laws or policy at national level, state level and local level, and in a very wide range of public policy areas which affect ordinary people's rights. The critical debate about ISDS has intensified in the last year after the European Court of Justice found that ISDS was incompatible with national sovereignty and that any trade agreement containing ISDS had to be separately voted on by each European national parliament. So the European Union is no longer including ISDS in its trade negotiations and agreements because it's so unpopular that they fear that if a trade agreement has ISDS in it, it won't get passed by national parliaments. So the recently concluded EU-Japan agreements and the EU-Vietnam agreements don't include ISDS, and the recent negotiations which started between Australia and the EU will not include ISDS. So the Australian government knows that and is not considering ISDS in the EU trade negotiations, but it's going ahead with it in the TPP 11. The US is also distancing itself from ISDS and is seeking to remove it from the North American Free Trade Agreement. And the latest negotiations that happened over the last couple of days has confirmed this, that that's one of the changes that they want to make, that they've been discussing with Mexico. So that's one of the first and most egregious aspects of the TPP and why we should oppose it. A second area that I wanted to talk about was less well known, but it's still very serious in terms of access to essential services, and that is that there's a series of chapters in the TPP 11 which encourage privatisation of essential services and make it harder to reverse failed privatisations. So these are chapters dealing with trade and services, competition policy, state-owned enterprises, and specific chapters on telecommunications and financial services. They don't force governments to privatise, but they prepare public services for privatisation by encouraging competitive tendering, which is open to international or foreign investors. And these chapters are structured so that all services are included unless they're specifically excluded, and they treat the regulation of services as if it were a tariff. So the idea is that you freeze regulation at current levels, and you can't increase it in future unless the service has been specifically exempted. So this locks in competitive tendering, deregulation and privatisation and makes them difficult to reverse. If we think about the massive failure of privatisation that occurred with the TAFE system, vocational education in Australia, over the last few years. Remember that there was massive fraud against students and against government through appropriating funds. And even the current Conservative government had to take some steps to re-regulate after that mess became public. But if the TPP had already been in place, other governments could have objected to that re-regulation. They could have said, no, this is against the rules of the TPP, unless there'd been very specific exclusion of private TAFE services. And there's a double whammy because, as well as other governments objecting, if there had been a private service provider from a TPP country who could argue that the re-regulation harmed their investment, the government could have been sued for millions of dollars by that private company under the ISDS provisions. So that's yet another example of how these trade agreements actually prevent governments from regulating in the public interest. If we look at the impact of the TPP on workers and the environment, it does have chapters on labour and environment, but the provisions are weak and they're not as enforceable as the rest of the agreement. Just to give a couple of examples. The labour chapter says government should endeavour to work towards an end to forced labour and child labour. But there's no enforcement of that provision. It's just an aspirational aim. And there are lots of exclusions for it. The chapter also basically says that government should enforce their own labour laws, but only in areas which relate to external trade and investment. And then, as I said, the actual enforcement provisions, making a complaint if the government doesn't enforce their own labour laws, is more difficult than other chapters in the agreement, and it's very long and hasn't proved effective in other similar trade agreements. Similarly, with environmental laws, there's a lot of mention of governments endeavouring to have better environmental laws, but only one international environment convention is actually enforceable, and that's about endangered species, the protection of endangered species. So there's nothing binding about climate change, for example, in the TPP. And of course, looking at workers' rights, there's also a part of the TPP on what they call mobility of labour, which actually treats workers as commodities in this trade agreement. And that is that it removes, and this relates to very vulnerable temporary workers. So I want to say, of course, that we support Australia's permanent migration program, which has resulted in the diverse and very precious multicultural population that we have today. But if you bring people on temporary work visas, they're tied to one employer and they have less effective rights than permanent workers. So because they can be deported if they lose that job. So they just are very vulnerable to exploitation. And we've seen numerous studies and parliamentary inquiries showing gross exploitation of these workers in terms of not being paid wages at all or not being paid the right wages, long hours, health and safety violations and so on. And what governments have been doing is using trade agreements to expand this vulnerable temporary workforce by removing the requirement to test whether local workers are available and allowing employers to bring in these temporary workers who are more vulnerable to exploitation. So the TPP 11 does do this, and it will increase the numbers of vulnerable temporary migrant workers, despite the fact that the current government, when there were all the scandals about temporary migrant workers about 2 years ago, said that it was going to introduce stricter labour market testing. But it hasn't done that. Instead, it's removed it through this trade agreement. The next area I wanted to mention is that it entrenches the question of medicine monopolies and also patenting of seeds and plants. Now, the TPP 12 had clauses in it which meant there was longer data protection monopolies on expensive biologic medicines used to treat cancer and other serious diseases, and it also had some provisions for longer copyright monopolies at the expense of consumers. All new medicines already have 20-year monopolies, so this is another example of using a trade agreement to make these monopolies even longer, which is of course the opposite of free trade. Now, these clauses would have delayed the introduction of cheaper forms of these medicines and cost our pharmaceutical benefits hundreds of millions of dollars a year. Now, these are some of the clauses that have now been suspended. So the biologic medicines ones have been suspended, but they could be brought back again if the US rejoins the agreement. But even with these clauses suspended, the TPP 11 locks in the current patent system of 20 years and enables patents to be extended for various reasons. And even a conservative body like the Productivity Commission has looked at the impact of patents, these form of medicine monopolies on the Australian economy and on the cost of medicines to consumers and the government, and have said that it's not a good idea to put any of those patent rules in trade agreements because future governments, it makes it very difficult for future governments to change them. The Productivity Commission has actually suggested that given the current state of the development of new medicines globally, it might be a good idea to actually reduce patents in future rather than put them into cement, which is what the TPP 11 does. And it's also not so well known that the TPP 11 forces the developing countries which are in the agreement to adopt rules for patenting seeds and plants. Now, in Australia, we already have those rules, but for the majority of, for developing countries, most of whom don't have those rules, and the reason they don't have them is because poor farmers in developing countries develop and use their own seeds, and that's through traditional methods of farming. If those seeds become patented, they won't be able to sale or swap seeds from previous crops, and they'll have to pay commercial prices to buy patented seeds. And the TPP 11 doesn't have adequate protections to prevent Indigenous seeds, plants and knowledge from being patented. I've got a leaflet here which summarises the issues I've been discussing, and I'd now like to talk about what we can do about it. We have been, the leaflet urges you to go to our website and send a message to your local MP and non-government senators to tell them to vote no to the TPP implementing legislation. And although non-government parties do have a majority in the Senate, this won't be easy because they have to make a decision to actually reject the legislation and therefore reject the whole agreement. If we look at the politics of it, the Greens and the Centre Alliance are opposed. The Centre Alliance is a bit more equivocal about it, but at the moment they are making public speeches saying that they reserve their right to oppose it. But Labor is divided, with the left, people like Pat Conroy from Newcastle making public speeches saying that they will oppose, or they want to oppose, the implementing legislation, but right-wing shadow ministers are reluctant to say no to any trade agreement. Our lobbying included a letter from 49 community organisations and most of the unions affiliated to the Labor Party, which was sent to all Labor MPs, reminding them that Labor actually has a policy against most of the aspects of the TPP 11 that I've described, including ISDS, medicine monopolies, etc. There's been a lot of personal lobbying by AFTINET unions and other community organisations. So tonight I'm asking you to keep up the pressure by going to our website and sending a message to non-government senators to say no to the TPP 11 and urging your friends and work colleagues to do likewise. And I'll hand out the leaflet which tells you how you can do that. I think that the next month is going to be crucial. There is also going to be a Senate inquiry into the actual legislation itself, which will be very quick, but that's just another forum where these issues can be aired and some more senators educated against it. Having said why we oppose the TPP 11, I just want to finish by outlining what a more just trade system might look like. It should be part of a balanced economic policy which contributes to employment and higher living standards in an environmental sustainable economy. We do need a range of jobs in manufacturing, services, agricultural and other sectors supported by high quality health, education and other services. We need a open trade system that includes all governments and not deals done secretly behind closed doors, and trade agreements shouldn't prevent governments from regulating in the public interest. Trade agreements shouldn't give additional legal rights to global corporations that already have enormous market powers, and they shouldn't be used to extend monopolies, and they should be based on internationally agreed and enforceable labour rights and environmental standards. So I'm happy to answer questions about the TPP 11 and about some of the broader questions I've raised, like Trump's trade wars. You might have seen today that the government's saying that it's almost finished negotiations for an Indonesia FTA, and there's other FTAs in the pipeline. I'd also just like to briefly draw your attention to a book that's being produced by the Department of Political Economy at Sydney University. It's called Wrong Way, and it's actually has a series of chapters which criticise neoliberal trickle-down economic policies, and my chapter is about trade policy. Evan Jones has got a chapter about financial services policy, and there's a whole lot of other chapters. It's being launched on Friday, September 21st at Glee Books at 6 p.m, and you can book on the Glee Books website if you're interested in that broader debate. So thank you very much.